Just to give you some background on us, we've been around over 25 years now, and all we do is implement, update drug-free programs for companies and administrate drug testing, which I'll explain what that means as the meeting goes on. Prior to implementation of the program is a company disciplinary action. What would happen if any employee ever failed a test in the future? He could go complete zero tolerance and say, hey, if anyone fails a test, they're going to be fired and they don't come back to work here. But the decision was made to go with what I call a second chance fire rehire type disciplinary action. If anyone did fail a test in the future, they would be dismissed. But if you go for substance abuse counseling at your own expense, because that's part of the state guidelines, and if a job is available, you may be rehired. So basically you would have to come back and reapply for a job. If Matt wants to give you a second chance, he could. He's not required to take you back if he doesn't want to. And you would have to pass a drug test in order to be rehired. There would be some paperwork that would be signed, and then they do have a right then to randomly test you at their discretion for a period of 2 years once you return. So it's a second chance type disciplinary action, but if you did fail a test, you would be dismissed, but at least you would have an opportunity to come back. Now, if you refuse to take a test, that's going to be a permanent dismissal. So the way this whole program works is that if you know you have to take, if you're going to take a test and you know you're going to fail it, you're better off taking it and failing it than you are by refusing to take it, because if you fail, at least there could be a second chance. Now, I'm going to also cover how drug testing works, and adulterated and tampered with specimens are considered refusals, so I'll get into all that. That falls in place here. The state, when they wrote the Drug-Free Workplace Act, said that if you violate the program and you're fired and you go for unemployment, they do have the right to tell unemployment that you violated the state drug-free program, and unemployment could be denied at that point in time. So that's also included in this. Okay, so like I said, at least there's you're doing the minimum requirements for what has to be done to comply with the guidelines here. Now, the drug tests, we're going to be testing for 10 substances. There's marijuana or pot, cocaine or crack, PCP or angel dust, amphetamine, speed, crank, crystal meth, opiates or heroin, barbiturates or downers, benzodiazepine or Valium. Everybody's laughing.
This is a long
Propoxyphene, Darvocet, Statavon's muscle relaxers, methaqualone and quaaludes, which are illegal, no longer made in the United States, and then methadone or methadone, which is what they give the heroin addicts to get off of heroin. So I'm going to cover the testing later on, but alcohol is part of this program also. Now, an alcohol test, though, is a separate blood test, and it's only going to be performed in certain situations. Alcohol is legal, but the way this is set up is that you're not supposed to be underneath the influence of alcohol while you're working. So to fail an alcohol test in this program, you do need a level in your system of 0.04 or higher. DUI is 0.08, so this is more strict than a DUI. But for somebody to have a 0.04 level during working hours, they would have either had to come into work very much underneath the influence or have been drinking while they work. Just to let you know, to reach a 0.04 level and the way testing works, you're really looking somewhere between 3 to 5 drinks, depending on how big they are, how strong they are, and how soon, the key here is how soon after you consume the alcohol that they actually do a blood test. Now, the way alcohol works is that whatever level you're at when you stop drinking, you come down a 0.015 level every hour. So let's say you're out for Monday Night Football, you're drinking a couple pitchers, watching the game, and at midnight, you're at a 0.1 level, even above a DUI. If you do the math and you're coming down a 0.015 level every hour, somewhere between, by 7 o'clock in the morning, you're at 0. So you're not going to fail a test if one was done the next day. Okay, but if you're out to 5 o'clock in the morning, you've been drinking for 10 hours, at 5 in the morning, you're at a 0.15 level, let's say, almost double a DUI, it's going to take 10 hours to get down to 0 or to 3 o'clock in the afternoon. So if they did an alcohol test,
Good, that's why I go to bed by 9.
if they did a test the next morning, you would fail the test. So that's the reason why alcohol is included, and like I said, it's only going to be done in certain situations that I'll cover in the meeting. Okay. Now, as far as testing situations go, all new hires are going to, effective immediately, all new hires are going to have to pass a drug test in order to come work for the company. So if any jobs open up or positions and you know someone that wants to apply for a job, you can tell them they're going to have to take a drug test in order to come work here. Everybody received in their packet some paperwork. There's the Drug-Free Workplace Employee Handbook. It's orange.
Some of them are green.
Some of them are green. Okay. This is the actual drug-free workplace policy and paperwork that the state says, contains everything that the state says you must be provided with. I'm not going to go through this on a page-by-page basis or anything, but you'll see if you look through the handbook, there's an outline of what is considered to be suspicion, accident and injury procedures, a list of medications that can affect the outcome of a drug test. There's a slew of confidentiality clauses. Everything that's in here is required under any state guidelines. You also have it's called an over-the-counter prescription medication disclosure form. Do not do anything with this form. I'll explain this form later on in the meeting. You also have the employment acknowledgement agreement form. That's the sign-off paperwork for the program that they would like to have you sign off on and then collect back by the end of the meeting. Okay. And then there's an open letter to the employees and a notice to all employees concerning the drug-free program. I'll be addressing the whole medical marijuana issue at the end of the meeting, but then there's the open letter. This is a 60-day notice. According to state guidelines, whenever a company puts this program in place, all existing employees must be given an initial 60-day period in which you are not tested for any reason. That this is supposed to be your period of time to clean up your act if you're doing something you shouldn't be doing. So figure it's dated today, March 26th. So the testing situation I'm about ready to go over will not come into play for you until figure May 26th on. Okay, so you have this initial 60-day period at the beginning of the program. Okay.
I don't have any sites on the paper.
Yeah. It's a separate, Okay, so once the 60, if anyone's ever injured on the job, basically a workers' comp claim, when you go for medical treatment, they will perform a post-accident drug test. Now, at the time of the accident, if there is suspicion of alcohol use, then the company has the right to request a separate blood alcohol test, as I mentioned, and then anyone who fails or refuses either test, then the workers' comp insurance company does have a right to deny your workers' compensation claim for that accident, and then you would face that fire, rehire, disciplinary action that I discussed earlier. Okay, so that's outlined in the employment acknowledgement agreement, that information. The company has a right, as we've mentioned, to test everyone at any point in time once the 60 days are up, but at this point in time, they are not going to test everyone. Okay, they're not testing everyone now, they're not going to test everyone after 60 days, they're not testing everyone once a year, or anything like that. They have a right to, so if it ever happens, it may come up. The company also does have a right to do random testing, but as of now, they're not going to. Policy says that the company may conduct random testing, so if they ever want to do it in the future without giving notice, they could. But random testing would be where they give us everyone's names. We'll put them on our computer system. They decide, pick 2 a month, 3 a quarter. Whose ever name pops out of the computer, it's like a lottery. You win a trip down to the drug testing site. You can start and stop. They can start and stop your hands at any point in time, but they are not required to do it as of now. There is another type of test called routine fitness for duty testing that is included in the paperwork. But the law and the policy says that if the company feels that there are certain employees who perform certain job duties or fall in certain job classifications that are deemed safety sensitive by the business, and once a year they want to test just those employees without testing everyone, certain people could be singled out based upon what they do. But if you fall into one of these types of categories, they would have to notify you in writing and you sign additional paperwork. Basically, if they wanted to once a year test everyone who drove a company vehicle, operated a forklift, a crane, heavy equipment operators, they could do that, but once again, at this time, that's not going to be in place. If they ever decide to put it in place and you fall into a category, they will provide you with notice and sign all paperwork. Now, the last type of testing, which will apply to everyone who works here, is reasonable suspicion. Now, everybody thinks suspicion has to be kind of a gray area. It's really not, because the law and your policy on the first page explains what reasonable suspicion is. So as long as an employee meets a definition of what is considered to be suspicion, they would have a right to test you for drugs or alcohol. If they ever have a suspicion case, I can guarantee you they're going to call me and get me on a cell phone and tell me what's going on so I can tell them what they can and cannot do. But I can break suspicion down into a number of different categories. One, if you're ever arrested for possession of illegal drugs and you're in jail, and that's why I didn't show up for work Monday morning because you got popped on Saturday night, when you do get out of jail and come to work, you would then be tested. If you're arrested for possession of illegal drugs in company, time, or property, they could dismiss you immediately. Two, if they ever catch you red-handed, smoking pot behind a dumpster, drinking on the job, snorting cocaine in a bathroom, drinking out of flasks, you laugh. I've had it happen. I've had people get caught snorting cocaine at their desk in their cubicle. So people get caught. So that will result in a test. If you have physical manifestations of being underneath the influence of drugs or alcohol, something that could be documented by more than one person. You smell like pot smoke, you smell like alcohol, you have a stagger walk, slurred speech, bloodshot eyes, mumbling and not making any sense more than the usual mumbling and not making any sense, then they'll test. A deterioration in job performance, which leads them to believe someone may be abusing drugs or alcohol. This is probably the toughest one to do because they need to build up a case. Increased absenteeism, tardiness, fights with coworkers, customer complaints. You're doing a lousy job. They could build up a case and then have you tested. A report of drug or alcohol use provided by a reliable and credible source, which is collaborated. Someone tells them that they saw you drinking today at lunchtime. The person giving them the report could have an ulterior motive. So there's two ways of collaborating a report. One would be by physical manifestations. So if they got a report, I was seen drinking today at lunchtime, and they come up and talk to me and I smell like a brewery, they're going to have me tested. Or another independent party considered to be reliable and credible tells them the exact same story. And the last type of suspicion is tied to accidents. Let's say Matt and I work together. I knock a shelving unit on top of him. I jump back, I'm not hurt, he's now injured and has to go for medical treatment and a drug test because he's hurt, and it was all my fault. So I could be tested for causing an accident that results in somebody else's injury. Or property damage. I'm driving a forklift and I forget the garage doors down in the warehouse. Come around the corner, smash. Now there's a broken forklift, there's thousands of dollars in damage. Thank God no one's hurt, but I can now be tested for causing property damage. Or any type of company vehicle accidents. So they will have a right to test in those particular situations. So that's how suspicion works. The one thing I want to also emphasize is that there are changes sometimes to the state drug-free workplace laws. And laboratory procedures and situations may come up that may cause the program to be modified. So we will keep in touch with the company, let them know if there's any changes that need to be made. So don't be surprised if at any point in time in the future you get a notice that says the drug-free program's been updated and this is the recent changes. So they're going to follow what they have to do to be considered drug-free underneath the guidelines.
Yeah, you talked about the building up a case for suspicion. Would you really need a case, or if you can do randoms at any time? Wouldn't that fall under the guys that have
Random and suspicion are two different things. Random is a lottery. Suspicion is meeting a definition of what is considered to be suspicious.
No, you could just categorize that under guys who are random test?
No.
If you do a random, it's completely random.
Yeah, it's a
Nobody
lottery.
knows who it is until after.
Yeah, and in fact, they're going to give us everyone's names. We're going to put them on our computer. They decide, pick 2 a month, 3 a quarter. That's a good question. I kind of skipped over that a little bit, but they decide how many names and how often, like 2 a month, 3 a quarter. So let's say they decide to do 2 a month, and we send over 2 names. they have until the end of the month to get the person tested. So basically, if you're out sick or you're on vacation, they can't pick somebody else to take your spot. Okay, they're going to wait for you to come back from being out sick or on vacation. It's not meant to disrupt the workforce. So they can get the list the first week of the month, but send the people the last week of the month, because there's a giant job going on. You guys need, or a couple jobs, you need to get them finished immediately. It's not worth taking someone off a job to send them down for a random test. But whenever they tell you you were chosen, then you would go immediately upon being notified. So it's not meant to disrupt things. In construction, and companies that do randoms, if they do outdoor construction, they wait for a rainy day. It's raining out, we gotta pull everybody off the job anyway, today's the perfect day to send so-and-so for their random tests. So they have control over when they could send you. We would generate the list though. Now, once your name is chosen for a random, you don't, your name doesn't come out of the pool. That way you can't say, hey, I got my random out of the way in January, now I can party the rest of the year. So you could be picked again, a month or two later, and meanwhile someone else has never been chosen. It's all completely random based on all employees at the time the list is generated. Okay, so that's what, completely random.
Every quarter, the same few people got picked in that lottery.
For what?
When I had my last job.
Well, if it's
The random, it seemed like the same two people every quarter.
yeah, the DOT requires random testing for CDL drivers, and that's so they follow those same type of procedures. So, there's the DOTs are really strict when it comes to that. But that's how once again, at this point in time, they're not going to be doing it. But if they do it, they have to wait at least 60 days, and that's how it will be handled. So to kind of answer, suspicion, randoms are randoms. Okay. Any other question on the testing situation?
I have one. I was just going to say that you do all that testing, this room would be almost empty. So no one's going to work for nothing. So the job will get done.
I'll talk in a second.
What I'm saying, that's all I'm saying.
Test them.
That's a good point.
Yeah, I've been on a job site where they've taken the entire crew, not just from one company, but multiple companies, and it was an oral swab. Is just like something like that?
Well, that would be a condition of a job.
Okay.
That would not be underneath. In fact, do you have anything like that happen where it's a requirement of any jobs that employees would have to take a test? Okay, all right. So that a job like that would be a requirement of the contract with the job. Post-accident procedures, if you get hurt, and then if there's ever a suspicion case on someone for drugs or alcohol, they're going to call me and I'm going to tell them what to do. So it's not like this is going to be a regular part of coming to work every day. If you don't get hurt and you don't give them suspicion, then you're not going to have to take a test. I've been doing this too long, and I have companies that call me, hey, you were out here 6 years ago and put our program in place. We've never had anyone fail a test. What do we do? So it's something that hopefully is not going to be an issue. Like I said, it's new hire procedures, accident procedures, and a suspicion procedure if it comes up.
Nothing's really going to change. If you guys got hurt, period, there would probably be drug testing involved anyway. So nothing's really going to change. So I don't want anyone to have any anxiety or freaked out about this. It's what we feel we should be doing. The way that it's set up is we feel beneficial for our company with the parameters that he's going through.
Okay, any other questions before I get into testing?
I got one. It's somewhere in here I read it talked about how the different states have the medical marijuana.
I'm going to get into that.
Okay, I was just wondering.
I'm going to cover. That's what I'm getting into next. All testing and how that works. Any other questions on the testing situations? Okay. The way drug testing works is that you go to a site and you give a urine specimen. They collect the specimen. It's then transported to the lab for testing. The very first thing that laboratories now do is they test for something called adulterants. Adulterants are products that you could buy online or in certain stores that are designed to throw off drug test results. So the labs actually test for the stuff designed to throw off the test. because there's a number of different types of drug tests out there. There's saliva kits, which don't comply with guidelines. There's instant kits that don't comply with guidelines. So some of the stuff that they sell will work on these other types of drug tests, but they don't work on the laboratory tests. There's substances out there. One's called clean. There's one called clear. There's one that's called Urine Luck, like urine luck. It's endorsed by Tommy Chong of Cheech and Chong fame. What these substances do is they throw off your pH levels and nitrate levels in your system so they cannot get to unnatural levels. So they cannot get confirmed positives on drug test results. So the labs now test for the stuff designed to throw off the test, and we do get results that come back an adulterated specimen. Technically, an adulterated specimen is considered a refusal to take the test. So it's grounds for dismissal, denying comp, unemployment. It's the same as failing, basically. So don't take anything to try to screw around with the test, because since it's considered to be a refusal, then at that point in time, the second chance fire rehire doesn't kick in. So you're better off, once again, taking and failing it than by trying to mess with it. Besides testing for adulterants, they're also going to test for what are known as foreign substances. Let's say you're going for a drug test and you know you're going to fail. And you decide you're going to put Drano, bleach, Tic Tacs, pool chemicals, solvents, detergents, pesticides into your specimen. A lot of that stuff like Drano and bleach could screw up the equipment at the lab. So the lab does an initial test before they even run the drug test to make sure there's nothing foreign in the urine specimen. If they find something foreign that shouldn't be there, then that becomes a tampered with test, technically a refusal to test, and it falls into that same category. So don't put anything in your specimen, because then it'll come back tampered with. Now, when they run the test for the 10 substances I mentioned earlier, it's a scale type test. So those substances have to be a certain level in your system to even fail. That way you can't claim secondhand pot smoke, because you're not going to have enough in your system from secondhand smoke to even reach what's called the positive threshold. It also eliminates the whole poppy seed bagel roll muffin thing. Poppy seeds do break down as an opiate. Heroin breaks down as an opiate. If you ate poppy seeds, your level of opiates is way down here. To fail, you need a level way up there. So that's a myth. Poppy seeds and secondhand smoke do not show up on drug tests. Now, in this case, negative is good and positive is bad. Negative results are downloaded from the lab to our office, and then we're allowed to release them directly to the company. If you pass your drug test, you never hear a thing. It just gets reported back to the company as negative, and you pass. Now, if it's positive, the lab automatically takes part of the original specimen, and they run confirmation testing on every substance that it comes back positive for. So what they actually do is they take part of your urine, they bake it to a powder, put it through a spectrometer, and then that adds a day, 2 days, 3 days extra at the lab for them to go through confirmation testing. Once they're done with their confirmation testing, it comes back to us as positive, and it goes to our doctor. We have a doctor on staff called the medical review officer. By law, it's his job to contact anyone who fails based upon the information you provide at the time of the test on the form, to go over the results of the test with you, and this will be before anything's reported back to the company. The reason this is handled this way is because people do have legitimate prescriptions. So if you have a prescription for something that showed up on the drug test, then you tell our doctor would then have to confirm your prescription with your doctor or pharmacist. You could take a picture of your pill bottle with your picture ID, send it over. He confirms your prescription and legally changes the result from positive to negative, and then it's reported back to the company as negative to keep the confidentiality of your medication. Now, if there's no medication reason, then it's going to come back as positive and the person fails. Now, just to let you know, it's illegal to take someone else's prescription medication. So don't take your husband, wife, girlfriend, boyfriend's prescription medication, because if it comes back, it shows up on the test, and you fail it, there's nothing anybody could do. It's going to come back as positive to the company. Okay. Now, legally, if 5 business days go by after we receive the results, and let's say our doctor just can't get you on the phone, at that point in time, we're allowed to release the results back to the company as positive without you speaking to the doctor. That way, you can't avoid the doctor and prolong the results for a month coming back to the company. So that's why if you ever have to take a drug test, the best thing to do if you get a phone call concerning it is just talk to the doctor about your result. And if you're on medication, as long as you have a legitimate prescription, you have nothing to worry about. You used to be able to bring your medication down for a drug test and they would write it on the form. But because of HIPAA from like 10, 15 years ago, they can't do that anymore. Now, part of the paperwork that was given to you is this, it's called over-the-counter and prescription medication disclosure. Part of the original Drug-Free Workplace Act says the company must give you the opportunity to divulge your medications if you choose to do so, making this form completely voluntary. You'll see on the bottom there's a bold note. Completion of this form is voluntary and will not affect the drug test process. You do not have to fill this form out. You do not even have to sign this. It's just required underneath current guidelines that the company must give you the form. So that's why it's included in the package. But once again, you don't have to fill out or even sign it. It just has to be provided to you as part of the package. And as long as you have a legitimate prescription, then you're fine. Now, if you do fail a test, and let's say you claim that this is ridiculous, I don't do drugs, the lab must have made a mistake, I demand a retest. Okay, you have a right to contest your results, but you do not go back again for another test. What happens is you get to choose another certified lab, who then sends a special courier to the original lab. They pick up the original specimen, take it to a second lab, and the second lab will run the exact same tests on the original specimen. You don't go for another test. Now, we don't have to pay for this to happen, and neither does the company. It runs about $200 to go through a contestment procedure. But if the second lab comes back negative, and the first lab did make a mistake, you're going to get your money back because the first lab's going to have to pay for screwing it up. But if it comes back, and it'll be changed from positive to negative. But if it comes back positive again, your original specimen has now been tested 4 times by 2 laboratories, and each time it failed, it remains positive and you forfeit your money. We've been doing this, as I mentioned, 25 years. We've administrated millions of drug tests. We've had a couple hundred people pay the money and go through the process. Believe it or not, at this point in time, we have never had one reversed. Now, people say that's got to be impossible. But if anything happens in the process to break what's called chain of custody, the lab will cancel the test. The seal broke, the specimen leaked, the plastic bag broke, paperwork wasn't filled out properly at the site, the label comes off, it spills. We get lists of canceled tests every day from the laboratory. So if you have a drug test or go for a test, there is a possibility it could be canceled by the laboratory because something happened. So the lab is more likely to cancel a test than they are to make any mistakes on it because there's just too much liability from their perspective of screwing it up, basically. So don't be surprised if if for some reason your test was canceled because the lab legally cancels the tests all the time. Okay, so that's how that works. Yeah, you can go back for another test at that point in time. Okay.
And then we can start. If it was canceled.
Yeah, then you would go back again for another test. Okay, so that's how you would contest the drug test result. Now, the medical marijuana issue. First of all, when it comes to medical marijuana, there are a number of different things. Number one, not all medical marijuana shows up on the drug test. CBD oils and some of the stuff they have out there, they don't have THC in it. THC is what gets you high, and THC is what will show up on the drug test. So, number one, you have to determine if you're going to go on medical marijuana, whether or not it has enough THC in it to even show up on the test, if it has any at all. Okay. Number two, if it does have enough THC in it to show up, it will come back as a positive result. Now, the state of Florida, when they put up medical marijuana for vote, we're only the second state in the whole country to have it as an amendment to the state constitution. Every other state has it as a law. So if they wanted to make changes to the law in other states, they just have to, their Congress gets together, says let's change the law, they vote on it, and then they make a change to it. In Florida, it's different because it's an amendment to the Constitution. So what happens is that they wanted to make changes to it along the way, You have to get 100,000 signatures, you have to then put it up for general vote, and it goes to a vote. So that's a big difference between Florida and the rest of the country. Now, once it was voted upon in the amendment, the state then had to write the whole amendment, and they put it into place. Governor Scott signed it into place a couple years ago. What happened was then, when they wrote the original amendment, they did two things that affected drug-free workplace. One, they eliminated smokable marijuana from the amendment. What happened then, it's all edibles, oils, pills, things like that. An attorney then sued the state and said, this is unconstitutional. We all voted to include smokable marijuana as part of the medical marijuana amendment. It should be included in the amendment, in what is legal to smoke under medical, or what we should be able to smoke or use for medical marijuana.
Morgan.
Yeah, Governor Scott kept appealing this case and keeping it in the court system, and his final appeal expired like a week or two ago. Okay, so what happened was when DeSantis came in as the governor, he said, I agree with the attorney. Smokable marijuana should be included in the medical marijuana law. So what happened was he said, I'm letting the appeals expire, and Tallahassee now needs to amend the amendment to include smokable in the state law, or in the amendment, I should say, and then to have it, and that's what's happened. Okay, all smokable marijuana has THC in it, so it's going to show up on the drug test. Now, the second thing they did when they wrote the amendment, there's a portion of the amendment which is still in place, and it says right in there, for the purposes of a drug-free workplace, an employer does not have to give consideration to an employee on medical marijuana and will not be held for wrongful termination or discrimination for not giving consideration. So the state medical marijuana law itself says a company does not have to accept the prescription. Remember, I talked about the doctor involved in the process in our office. According to his license and according to his certification, he is not allowed to change a result from positive to negative based upon someone having a medical marijuana prescription based upon the federal law. On the federal basis, it's still an illegal Schedule I controlled substance. So no matter what, it's going to come back to the company as a positive test result. So every labor attorney I've spoken to concerning this have all said the exact same thing. The company treats one positive different than another positive, they have a discrimination issue. Not to mention a liability issue, which I'm going to cover in a minute. So basically, that is why there's wording you were given addressing the medical marijuana issue, saying that if you are on medical marijuana, you should check with your prescribing physician, number one, to see if it has THC in it, and enough that will show up on a drug test. And basically, it's going to be treated as any other failure. Your question about other states, it's already gone to the Supreme Courts of Colorado, Washington, Oregon, and California have all said the exact same thing. Based upon the federal law superseding state law, an employer does not have to give, has a right not to hire an applicant, or has a right to fire an employee who fails the test for marijuana, even if they have a medical marijuana prescription or recreational users in those particular states. Everyone I've spoken to concerning this has all said the same thing. From an employer perspective, it needs to be treated as a positive until either the federal government changes its stance or there's a ruling by the Supreme Court of Florida that says you have to accept it. Now, going back to the liability aspects of it, I've had owners of companies tell me, hey, as long as they don't do it during working hours, I don't care what they do on their own free time. The only problem with that is there is no test to determine, like a breathalyzer, that you're underneath the influence of alcohol now. Okay, so there's no test to determine you're underneath the influence of THC now. So basically, you trying to determine whether or not someone's underneath the influence at that time, there's no test to determine that. Plus the liability aspect of this, I had an electrical contractor in November. The owner of the company called me in December freaking out because of what happened. They had 3 outstanding new hire drug tests that were ready to that she was waiting for the results. She decided to go away to a convention. She left her assistant in charge of the drug test results and said, when they come in, if they pass, put them to work. If they fail, you're not allowed to hire them, and don't put them to work. One of the guys failed for marijuana, went up to the assistant and said, here's my medical marijuana card. I have a prescription for this. It's legal for me. I should be able to work here. Instead of the assistant calling us or calling the owner, put the guy to work. 3 days later, he fell off a roof. There's now a $200,000 workers' comp claim against the company and the insurance company. And everyone that was they did an accident investigation. Everyone said that worked with the guy, number one, he should never have fallen off the roof. And number two, he was definitely underneath the influence of something the whole time he was here. So basically, you have to look at this as there's a huge liability aspect for the company accepting it. Basically, if they accept it, which they really can't, then you give someone the go-ahead to use it during working hours, and they could injure you or fall off a roof and get hurt or so on. So until anything changes, both from a federal level, a state level, it's going to be treated as a positive test result. Does that answer everyone's question concerning medical marijuana?
Yeah.
And the reasons why it's handled the way it is?
Yeah.